All right, good afternoon, Beasley. Are you ready on, is this Austin Walker?
Yes, Your Honor.
All right, let me flip back there to my docket. All right, court calls, cause number CR 2200 and 232, State versus Austin Lynn Walker. I show we're set for a docket call today. Any announcements, Ms. Beasley?
Your Honor, we request an additional setting. My client has a co-defendant, and it's my understanding that Ms. Curry would like to dispose of these at the same time. And we're in the process of trying to negotiate. We haven't completed that process yet.
State.
Judge, that's my understanding as well.
Do we know how long? Do you want me to look up the co-defendant? Do you know how long you're wanting, Ms. Beasley?
I want about 45 days, Judge. My case should resolve after the co-defendant does.
After the what does? Co-defendant?
After the co-defendant.
Do we know when the co-defendant said again?
Judge, I can look real quick. We just had her last week. I have it written down here.
I think it was Tuesday.
It's April the 13th, Your Honor.
So what would the court like?
You're gonna laugh when I tell you, but I would want April 15th.
No, sir, that's fine.
Is that fine?
That's fine.
We-
I'm right here on the 15th.
Okay, good. All right, then we'll set Mr. Walker then for an additional docket call on April 15th at 1:30.
May he be excused, Your Honor?
Yes, ma'am.
Thank you.
And Ms. Beasley, I show that your other client, Michael David Mason.
Yes, sir. He is currently still in custody in Gregg County. The attorney that actually is representing him on that is Mr. Parrish, and he's actually here at the jail. I think he has another case, client on your docket this afternoon. It's my understanding he's been working with the DA's office in Gregg County. He's had one offer. A second prosecutor got involved and did a much higher offer. And so they are, I believe, having their last final pretrial hearing next month. That's their final pretrial setting. And then they're going to do, if they can't get it resolved by that time, they'll go to a trial.
Okay, that's CR 25-6. We'll set Mr. Mason then for another status on Gregg County custody on April 15th.
Yes, sir. May I be excused, Your Honor?
Yes, thank you, Ms. Beasley.
Thank you, sir.
All right, Mr. Sanders, is this Cody Eden?
Yes, it is, Your Honor.
All right, this is cause number CR 2385, State versus Cody Christopher Eden. We're set for pretrial.
And Judge, we don't have any contested pretrial issues, and we just asked to have it set for a docket call.
All right, court will set Mr. Eden for a docket call on April 15th. I believe that's in line with what we set you on earlier cases this morning. Is that right, Mr. Sanders?
Yes, that's correct.
All right. So we'll see you again on the 15th, Mr. Eden. And on that date, what the court's going to want to hear is whether or not this case is going to be resolved by plea agreement or whether you're going to be requesting some type of trial either before the bench or a jury trial, okay? All right. We'll be adjourned in this matter.
All right, thank you, Judge.
Gimbel? Wilburn?
All right, this is cause number CR 2275, State versus James Grady Wilburn. And we're set for docket call today, Mr. Gimbel.
That's correct, Your Honor. Mr. Wilburn and counsel are present.
What's your announcement on docket call? Have you received an offer? Is he going to accept it? Is there a counter offer?
We have received an offer, Your Honor, and Mr. Wilburn is not interested in accepting that at this time. He did explain to me he is interested, his family is making financial arrangements to retain private counsel at this time.
Okay, well, until the time that there's a motion to substitute counsel, the court's going to proceed in setting this case for jury selection. Mr. Wilburn needs to understand that passing today's docket call and asking the court to place it for jury selections going to mean that if Mr. Wilburn or the state decide that they want to enter into a different plea agreement, the court may not accept that or allow that. Does he understand that?
Yes, sir.
Okay. All right, then we're going to set you for jury selection beginning on April 5th. So if you're incarcerated, Mr. Wilburn, then once your case is selected for trial, we will notify you. We'll be notifying your counsel, whoever that is, throughout this time. If you make bail in the case, then you will have to report to the courthouse at 8:30 on April 5th for jury selection. Do you understand?
Yes, sir.
Doesn't mean that your case is going to go to trial on April 5th. I want you to be clear on that. It just means that you are getting on the list of the jury trials.
Yes, sir.
All right. So once you fill out that notice of setting, give that to Mr. Wilburn, then he can be returned to his cell.
And that is all I have this afternoon, Your Honor. May I be excused?
Yes. Thank you, Mr. Gimbel.
Yes, ma'am.
She wanted to do your thing.
Well, Your Honor, how are you?
I'm doing fine. How are you doing?
I'm doing good. Jason Parrish here on behalf of Mr. Gray. He's running a little late, and I'm waiting on him to show up. I've got his paperwork ready to go. And
Okay.
he sent me a text message saying he was running a little bit late, but I've got everything ready to go. So as soon as he gets here, I'm going to get him signed up.
Yes, sir. Sounds good.
Thank you, Your Honor.
You're very welcome.
Yes, sir. Yes, sir. I agree. Your Honor, I think Mr. Stevens is here now with his client.
Okay.
That's okay.
All right. And who do you have with you, Mr. Stevens?
I got Mr. Williams with me, Your Honor.
All right. Cause number CR 19-224, CR 20-146, State versus John Charles Williams. I show we're set for docket call today. What's Mr. Williams?
Yes, sir. We've not reached an agreement with the state, Your Honor.
Can I speak up for a second, sir?
No, you may not.
I mean,
You may not.
okay.
Mr. Stevens, does that mean that Mr. Williams is rejecting the plea, or does that mean you're not ready?
Wait 1 second, Judge.
If you want to, Mr. Stevens, just go ahead and step away and you can speak with him privately. Do we have anyone else, bailiff, do we have anyone else in the courtroom that's ready?
No, sir.
Okay.
We're still waiting for that one to show up.
Yeah.
It's 30 minutes late. We'll see.
We do have more inmates on the way up though, correct?
I believe so. I'm not sure.
I've got one.
Got one more?
Judge, this was Mr. Wilson. I had the wrong file in front of me. I apologize to the court. Mr. Wilson.
Okay. All right, so this is William Andrew Wilson III.
Yes, sir. Correct. Yes, sir.
Is that correct? All right, CR 18-521, 522, CR 19-327, State versus William Andrew Wilson III, set for pretrial. Go ahead, Mr. Stevens.
No formal pretrial matters, Your Honor.
Your request to set this for a docket call, and
Yes, sir.
have you received an offer from the state?
I have, Your Honor. Yes, sir. It's 25 years is the offer.
And Mr. Stevens, your client wanted to speak to the court. Have you addressed his question, or is there some line of questioning I need to engage in with Mr. Wilson?
No, Judge, we've taken care of that.
You agree, Mr. Wilson?
Yes, sir.
Okay. All right, then we'll set Mr. Wilson then for a docket call on April 13th. Are you still good for that afternoon, Mr. Stevens?
Yes, sir, I am.
And we'll set that at 1:30. If Mr. Wilson makes bail, his time to appear would be 9 a.m.
All right, sir.
And once he gets his notice of setting, then he can be returned.
All right. Now I have Mr. Williams, Your Honor.
All right. All right, cause number CR 19-224, CR 20-146, State versus John Charles Williams, set for docket call.
Yes, Your Honor. We're just going to ask you to do it on another docket call or the jury docket, either one.
Well, the court views the docket call different than jury selection. What's the offer in the case, and is Mr. Williams rejecting that, or y'all still trying to negotiate?
We're still negotiating, Judge. It's been 25, but we're still negotiating. So let's do another docket call then, Judge, without
So,
a trial docket.
So Mr. Williams has the same offer as Mr. Wilson, 25?
Yes, sir.
And how long has Mr. Williams had to discuss that with you, the 25-year offer? How long has he been considering that?
Well, I'm the third attorney on this, Judge, so I'm not real sure. I met with him for the first time in December, and I think at that time he knew what the offer was. So,
State, do you believe this is going to be the best offer you extend to Mr. Williams?
Yes, Your Honor. I believe there was a previous offer for higher. This was Mr. Cox's case, but I do believe that our starting offer was significantly higher than the 25 that's currently on the table. And I don't believe that it's going to come down any.
Judge, I would note there is also an unindicted PCS case that we are still awaiting the drug labs on. I am directing my investigator to check into the status of those. It looks like we've been waiting on them for some time.
But they're independent and separate from this case, is that correct?
That is correct. It is from a different occasion from these cases. It is subsequent to these cases, but there is that additional case as well.
All right, seeming as the state has made what they've indicated as their best offer is, Mr. Williams, are you rejecting 25 years TDC today?
Yes, sir.
Are you requesting a jury trial?
I guess I'll have to.
Okay, then the court's gonna set you for jury selection beginning April 5th. If you're in custody, then you won't need to do anything. We'll bring the information to you. Your case will not go to trial on the 5th. However, you will be placed on the list of cases to be tried. So once your case works its way up to the top of the list, then you'll be notified, as well as Mr. Stevens. If you make bail on the case, then you will be required to appear at the courthouse on April 5th at 8:30 to get further instructions from the court. Do you understand?
Yes, sir.
All right. Once Mr. Stevens fills out that notice of setting indicating jury selection on April 5th, once you receive your yellow copy, then you're free to go.
That's it for me, Judge. Might be excused.
Yes, thank you, Mr. Stevens.
Your Honor,
Yes, ma'am.
we are waiting for the next batch of inmates to come up. I will let you know that I've requested for Mr. Wood's clients to be brought up next.
Okay, thank you. I think Mr. Wood had a rush fee, so I don't want to have to refund that, so I'm glad he's next.
Do my best.
Thank you.
That is correct, Judge, and that's going up by the minute.
By the minute.
We're doing a GoFundMe account for my haircut, so that, feel free.
Mr. Woodwag says he's not going to make any donations for that.
I have no comment, Judge. You have finally found something I will not comment on.
Catching strays wasn't even in the conversation.
Do you want some, Mr. Alton?
No, I would like to just stay muted. I'll turn my video off if necessary.
No, please don't. You can though. If you want to turn your video off until your client's there. I know that you gentlemen are busy and you got other clients and other cases. You're welcome to do that. And then whenever your client comes on, I'll ask if you're there. So feel free to do that. That way, if you need to get up and move about your office, you can do so.
I'll keep the comically large headphones on, Judge.
Don't steal my thunder now. I need all the material I can get.
I've got to get it in before you do. I have a judge here in Kaufman that makes a quip about the headphones every single time I'm on Zoom. It's perfect. I know it's coming every time.
Is it Judge Gray?
No, it's Judge Rich. Says, there you are, Mr. Alton, headphones and all.
Headphones and all.
They're still here.
I'm not going to say anything until you get one of those mouthpieces that extends over. It makes you look like a pilot. When you do that, then I'll be forced to say something.
I'll make a note of that.
Yes, sir. Take the mouse. There it is.
Ms. Burns, are you out at the jail?
Yes,
sir.
Oh, okay. Miss Mary Dean has contacted the court for permission to appear at the Justice Center from this morning's docket. I've indicated to her that she can appear,
Okay.
but I would like her drug tested before the hearing.
Yes, sir.
Thank you.
Come on, guys. Mr. Welburn, come on, guys. Get one more. Oh, that's right. Okay, thank you. Yeah, the other one's a trustee. He's on his way up. I'm sorry. Mary Dean? No, ma'am.
Gotcha,
You asked her a question, it was muted, so I turned back on.
gotcha.
All right, Your Honor, we do have Mr. Wood's clients here. The only one that's missing currently is Mr. King, but he is on his way in. So we have Mr. Bruner and Mr. Welburn.
So he's not missing, he's just in the back.
Correct. We know where he is. He's just not present.
Okay. All right, who do we have up first for Mr. Wood?
Mr. Welburn, come on.
Judge, Mr. Welburn's going to be a plea to both of his cases. He's got a possession of controlled substance and a DWI that was transferred to you.
Yes, sir. I believe I have that here. All right, Mr. Welburn, if you will, raise your right hand, sir. I'm going to place your oath. Mr. Welburn, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Just make sure you speak up loudly and clearly today so my court reporter can hear you and we can take down a clear record, okay?
Yes, sir.
All right, that's very good. All right, are you Cody Lee Welburn?
Yes, sir.
And Mr. Welburn, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeffrey Wood. Are you pleased with Mr. Wood's representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the plea agreement that you do not understand?
No, sir.
Mr. Wood, do you believe your client to be competent today?
I do, Your Honor.
And you explained to him his legal and constitutional rights?
I did.
And Mr. Welburn, if your name appears throughout the plea agreement, I'm going to show you what I'm looking at here. Attempt to show you anyway. Mr. Welburn, would you tell me that that's your true and correct signature?
Yes, it is.
All right, and you've only signed these documents once. You were comfortable that you understood what they were saying. Is that correct?
Yes, sir.
All right, Mr. Welburn, it appears that you have two cases before this court. One of them is a possession of controlled substance in penalty group 1 less than 1 gram. The other is a driving while intoxicated. It appears that you want to enter into a plea agreement with the state on your felony drug case of possession of a controlled substance in penalty group 1 less than 1 gram. It appears that the plea agreement is that you would plead guilty to that offense in exchange for the state's recommendation after they abandon the enhancement paragraphs that punishment be 18 months confinement in the state jail division of TDC with a $1,500 fine, $180 restitution, with the state rejecting a few cases under section 1245 of the Texas Penal Code, those being possession of controlled substance in penalty group 3 and a possession of marijuana less than 2 ounces. And then in the DWI case, the agreement is upon you pleading guilty, the state recommends that your punishment be 170 days confinement in the county jail with you receiving credit for 170 days towards your sentence with a $100 fine. In that case, you would have $270 court cost and $515 reimbursement fee. Mr. Welburn, is that your understanding of the plea agreement in each case?
Yes, sir.
Yours as well, Mr. Wood?
That's correct, Your Honor.
All right, Mr. Welburn, the range of punishment in your felony drug case is that it is a state jail felony and carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC, and also a fine not to exceed $10,000. Do you understand the range of punishment in that case?
Yes, Your Honor.
And in your DWI case, the range of punishment is a Class B misdemeanor, is a maximum up to 180 days confinement in the county jail, and also a fine not to exceed $2,000. Do you understand the range of punishment in that case?
Yes, Your Honor.
All right. The court finds that, as stated, the plea agreements each fall legally within the range of punishment. So at this time, Mr. Welburn, I'm going to ask you, how do you plead to both possession of a controlled substance in penalty group 1 less than 1 gram, unless you have occurred on September 13th of 2020? And how do you plead to driving while intoxicated, a Class B misdemeanor, unless you have occurred on September 22nd of 2020?
Yes,
Do you plead guilty to each?
on both charges, yes, sir.
All right. And Mr. Welburn, are you pleading guilty to each charge because you are guilty of committing each charge?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to either one of these charges?
No, Your Honor.
All right, the court will accept Mr. Welburn's plea of guilt at this time. Mr. Wood, is there any objection to states one in each case?
No objection, Your Honor.
States one is admitted, and the court takes judicial notice of Mr. Welburn's judicial confession. Is there anything further from the state?
No, Your Honor, there is not.
Mr. Wood, from the defense?
Nothing further from the defense.
All right, I'm gonna take just a brief moment and review the evidence. All right, Mr. Welburn, based on the court's review of the evidence, I find that there is sufficient evidence to convict you of these offenses. The court will follow the plea agreement that you reached with the state. In cause number CR 2417, the court convicts you of the state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram, assesses your punishment at 18 months confinement in the Texas Department of Criminal Justice State Jail Division. Court assesses a $1,500 fine, orders restitution of $180, and dismisses under section 1245 under the Texas Penal Code DA 2020-877 and DA 2020-878. Court also assesses court costs of $290 and orders reimbursement fees of $20. The court also awards you 170 days credit towards your sentence in that cause for time already served on that case. With regards to cause number 2020-668 on the charge of driving while intoxicated, the court hereby finds you guilty of that offense, assesses your punishment at 170 days in the county jail. Court awards you 170 days for time served in that case. Court also assesses a $100 fine, $270 court costs, and orders you to pay reimbursement fees of $515. Mr. Welburn, whenever you get out of TDC, I'm going to order that you contact the Van Zandt County Courthouse so you can speak with the court compliance collections officer so that you can make arrangements to discharge the money that you owe. The court and the compliance officer can put you on a payment plan so that you can stay out of jail. If you don't contact the courthouse and you don't speak with the compliance officer and you don't make either a payment of all of this at once or get on a payment plan, then what's going to happen is the court's going to issue a KPS pro fine warrant and have you rearrested. You understand?
Yes, Your Honor.
Okay. All right, Mr. Welburn, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. And Deputy, I have the paperwork here. I'm going to sign that and we'll bring it over for his fingerprint.
Thank you, Your Honor.
Mr. Wood, I'm going to ask you to come to a breakout room real quick. I got a question for you about your bill real quick. I want to make sure I'm understanding it correctly.
Okay.
All right, give me just 1 second. All right, is this Mr. King?
This is Mr. King here, Judge.
All right, this is cause number CR 2345, State versus James Dale King, set for pretrial today.
That's correct, Your Honor. This is the first pretrial, Mr. King. I'm still working on putting together some things for the prosecutors in this case. Talked to Mr. Woodwike about Mr. King yesterday briefly. It's my understanding that it was somebody else's case initially, but I think either he or Hillary have taken it over. Nevertheless, we're asking for a new pretrial, a new setting on this one to hopefully I can get that stuff over to them and we can get something in the works.
Do we have any issues with the state's discovery at this time? Any contested pretrial motions or anything?
No, nothing that I'm aware of at this point, Your Honor. I picked up the CD today, as a matter of fact. I've had the paper discovery for a while, but I don't anticipate any pretrial issues coming up.
All right, so let's do this. I'll set this for docket call since there's no pretrial discovery issues. We'll set it for April 27th. That should give you some time to get your stuff together and give that to the prosecutors. So we'll set this for docket call on April 27th at 1:30.
Thank you, Your Honor.
You're welcome. Mr. King, once you sign this piece of paper the bailiff has with you, then we'll give you the yellow copy and then you're good to go.
Yes, sir.
All right, do we have any other clients for Mr. Wood? Mr. Bruner? I think it's his last one.
Yes, Your Honor, he's on his way.
All right, excellent. All right, this is cause number CR 2041 and 42, State versus J. Michael Bruner. We're set for status on his competency evaluation, I believe.
I think that may be right, Judge. I talked to his the psychiatrist, I guess, last week. It was early last week, provided him all the information that he needed from us. Then he mentioned to me that he was going to try to get there to see Mr. Bruner sometime last week. I'm not sure if he ended up making it or not, but I anticipate that he'll be there relatively soon to talk to Mr. Bruner.
All right, I was going to check the filings to make sure he didn't file a report already. All right, so let's reset this for another status on the competency evaluation. A little hesitant to set it out to the 27th. It just seems like quite a ways. Are you available at all on April 1st, Mr. Wood?
April 1st. Yeah, Judge. I mean, I can be available.
Okay. Of course, you can zoom in for the hearing if you need to. Just don't want to set it so far out because if the order comes back with certain findings, then I want to be able to address that with you and Mr. Bruner and, make any other orders I might need to based on that. So.
Yeah, fair enough. I hopefully he'll be there to see him soon and something will be back soon. So.
All right, we'll set it for a status on the competency eval on April 1st, 1:30. All right, Mr. Bruner, does he have his yellow copy of his reset notice? If you can fill that out for him. All right, Mr. Bruner, we'll come and visit with you again on April 1st. Is that all you have, Mr. Wood?
Judge, I believe that's all I have.
Thank you, sir. I appreciate you.
All right. Thank you, guys. Good to see you.
See you soon.
All right.
Sorry about that, Your Honor. We do have Mr. Ethan Medell in the room, but we also have a Mary Dean out in the lobby as well right now.
All right, and is Mr. Jones there in the courtroom, in the jail court? He's the attorney for Mr. Medell?
No, sir, I thought we had Mr. Knoll.
Oh, Mr. Knoll? Well, it says on the paperwork, it says Dennis Jones.
Gotcha. I might visit with your coordinator if she's.
He was my original attorney before they released me and opened the case back up. And then they gave me criminal.
I do have Mr. Knoll online. Let me bring him in. State, we're gonna need to fix that on Mr. Medell.
We'll get right on it, Judge.
All right, Mr. Medell, we're bringing Mr. Knoll in. Once he gets connected, we'll start your hearing. Mr. Knoll, can you hear me at all? All right, good afternoon, Mr. Knoll. Can you see and hear me now?
I can, Judge, but I started a Zoom hearing in the other court. I'm in the 7th District Court on my laptop. Can I check back in about 10 minutes?
Yes, sir.
Okay. Thank you, Judge.
You're welcome. Mr. Medell, I don't know if you heard that, but he said that he was in the district court in Tyler and Smith County on his laptop, and he asked if he could check back in about 10 minutes.
Yeah, I got it pretty open.
Yeah, okay, good. So go ahead and have a seat, and we'll get right to you, okay? Thank you, sir. Ms. Burns, just let me know whenever I have that information on Ms. Dean.
Yes, sir.
And do we have Ms. Hayes on her way up for Mr. Altum?
I'm getting her brought up right now, Your Honor.
All right, thank you. I appreciate it. Well, they need to correct it. It's got the wrong.
Swears in open court like we are now, with their lawyer, that everything on the stipulation is true and correct. They are admitting to the charge made against them. You understand that? Yes, sir. Everything on the stipulation of evidence made is true and correct. Yes, sir. All right. And did you get a copy of your indictment to sit down and be able to go with your lawyer? Yes, sir, I did.
Your Honor, if you have a moment for a question, please.
Yes, ma'am.
I'm here with Lieutenant Harrelson over the jail, and she's got a question about a bench warrant and some coordination she's trying to work out.
Yes, ma'am.
One you signed on Brandon Alexander?
Yes, ma'am.
Okay. Do you know if that'll be is it going to be multiple court proceedings? Like, is it just one day? I'm trying to get him returned the same day. It cuts down on a lot of paperwork and time sitting here. So if I can get him back same day before midnight, they'll accept it.
I'm not certain. Ms. Curry asked me to do that. It's in conjunction with a CPS case for him to be able to speak with his attorney who's representing him as the father of a child. So I'll tell you what, give me until tomorrow.
Yes, sir.
I'll if I can nail down that information with Mr. Elliott and Ms. Curry, and then give you what you need. So you're saying that if you can get him returned the same day you pick him up, they'll take him?
Yes.
And that's preferable for you?
It is. It cuts down about 6 weeks, if not more, wait time.
Wait time for him to have to go back? I got you. Okay. All right. Well, I'll get on that right now, and I'll let you. If I can find out today, I will.
Okay. Thank you.
Hey, you're welcome.
And Your Honor, we do have Ms. Hayes in the room now.
All right. Let's go ahead and bring her up. All right, good afternoon, Ms. Hayes. How are you?
Okay.
All right, this is cause number CR 20-122, State versus Amy Marie Hayes. Ms. Hayes, if you'll raise your right hand, I'm going to place you under oath. Ms. Hayes, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. You're soft-spoken, so I want you to speak up loud and clear, okay? So my court reporter who's present with me in the courtroom can hear everything we say. The louder you talk is better, okay? So you're not gonna get in trouble for talking real loud, okay?
Okay.
All right, Ms. Hayes, are you a United States citizen?
Yes, I am.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
No.
No?
No.
Okay. And in this case, you are represented by your attorney, Mr. Gilbert Altum. Are you pleased with his representation of you?
Yes, sir. I am.
Okay. All right. And you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
All right. Mr. Altum, do you believe Ms. Hayes to be competent today?
I do, Your Honor.
And you've explained to her her legal and constitutional rights?
I have, Your Honor.
All right, and it appears that Ms. Hayes was charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. And the plea agreement is that the state will proceed upon a plea of guilt under section 1244A of the Texas Penal Code, meaning that Ms. Hayes would be convicted as a state jail felon, but she would be punished as a misdemeanor at 200 days confinement in the county jail, with her receiving credit for 200 days with a fine of $3,500 and $180 restitution, in addition to court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. Altum?
Yes, Your Honor.
And yours as well, Ms. Hayes? Is that what you understand to be the plea agreement?
Sir.
All right, Ms. Hayes, the range of punishment for a state jail felony offense under section 1244A is confinement in the county jail for a period not to exceed 365 days and a fine not to exceed $4,000. Understanding that range of punishment and the court finding that the proposed plea agreement fits within that range of punishment, how do you plead to the offense of possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty or
And Ms. Hayes, are you pleading guilty to that charge because you are guilty of that charge?
yes.
All right. And has anyone threatened you, forced you, or pressured you to make you feel like you had to plead guilty? And say that again, I couldn't hear you.
No, sir.
Okay. All right. The court will accept Ms. Hayes' plea of guilt at this time. Mr. Altum, any objection to States 1?
No, Your Honor.
All right. States 1 is admitted into evidence. The court takes judicial notice of Ms. Hayes' judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
I would just ask, I muted myself. I would just ask that you sign my motion to pay court-appointed attorney's fees, Your Honor.
Yes, I will do. I'm gonna take a brief moment to look at the evidence. Looking for the evidence. I'm not finding it. Let's see if it's in this stack here. All right, state, I don't have any evidence to support the plea.
Judge, I will get that over to you. I'm looking through my emails to see if we have that already in electronic form. If not, I will shoot that over to Ms. Abraham via email right away.
All right, if somebody can summarize the evidence for me.
Yes, Judge, if you'd give me just 1 second to pull up my notes here.
Yes, ma'am.
All right, Judge. Van Zandt County is called out to the Rolling Oaks addition on reports of a suspicious vehicle in the middle of the road. The officer makes contact. The driver of the vehicle is acting very nervous, making sudden movements. Asks if there's anything illegal in the vehicle. They say no. They allow the officer to search. The officer immediately finds a container in the middle of the bucket seat that has a baggie of meth inside of it. When asked who the meth belongs to, Ms. Hayes, who is the passenger, claims it as hers. And let me look and see here what the lab came back at. Lab came back confirming 0.32 grams of methamphetamine.
All right, Mr. Altum, any objection to that summary? You've reviewed the evidence and you've seen the evidence. Any objection?
No, Your Honor. I believe that that sums it up.
All right, Ms. Hayes, based on the court's review of the evidence, the court will find that there is sufficient evidence to convict you of this offense. The court hereby convicts you under Section 1244A of the Texas Penal Code of the offense of possession of a controlled substance, penalty group 1, less than 1 gram, assesses your punishment at 200 days confinement in the Van Zandt County Jail. The court will give you 200 days credit for time served. Towards your sentence, the court assesses a fine of $3,500. Court also assesses restitution of $180, orders you to pay reimbursement fees of $585 and court costs of $290. Upon being released from the Van Zandt County Jail, I'm going to order you to contact the Van Zandt County Compliance Officer, Miss Bonnie LaPrade, and discuss with her how you're going to pay off your fines and court costs and reimbursement fees. Your failure to do that is going to result in the court issuing a warrant for your arrest. Do you understand?
I understand.
All right, thank you, Ms. Hayes. All right, Ms. Hayes, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And bailiff, I'm going to send the judgment out to you to have her fingerprinted. Unless you have the original judgment there that has a fingerprint on it, I've got something that has faint, looks like somebody attempted a fingerprint, but I don't know if this is obviously a copy. I don't know where the original is, but I went ahead and signed this one. I'm just going to have this sent back out for her fingerprinting.
We'll take care of that, Your Honor.
Thank you. I think Ms. Abraham send it that way.
Your Honor, I don't know if this is going to change your itinerary for the afternoon, but Miss Mary Dean, who had been waiting out in the lobby for you to be ready for me to call her, decided to take off, and I was notified by her bondsman, and we actually drove about a quarter mile down the road and caught her in a grass ditch, put her in the truck and brought her back. So she's sitting here in the courtroom now where she's going to stay unless you would like to speak with her right now.
No, Ms. Burns, do you have any, and Mr. Altum, I'm through. Do you have any further business?
I do not, Your Honor. May I be excused?
You may, or you're welcome to stay for the show, whatever you want to do.
I was considering it, Judge, but I think
Go
I
ahead.
probably should get to work.
All right. Ms. Burns, do you have any additional information regarding your analysis?
No, sir, she's unable to provide a sample right now.
Okay. All right, then, yes, Ms. Dean, if you'll go ahead and step up in front of the camera. This is cause number CR 2288, State versus Mary Louise Dean. Ms. Dean, the court called your case this morning at 9 a.m. You were not present. Your attorney, Ms. Thompson, was present, and she indicated to the court that she was going to ask for more time on your case, asking the court to reset it. The court took a judgment and I signed your case under advisement till noon. I was then contacted right after lunch that you wanted to appear, and so the court authorized you to appear. However, I have asked for you to provide a urinalysis specimen, and based on the information being provided to me at this time, the court is going to find that your bail in this case is insufficient. I'm going to find that you failed to appear at court as directed and that you have failed to provide a urinalysis exam. So the court's going to find your bond insufficient at this time, and we're going to take custody. And I'm going to set your case. I'm going to set your case in just a moment. So go ahead and take her into custody at this time and have her have a seat. And I will get her scheduled in just a moment, and we'll send that notice to Ms. Thompson. All right, if Mr. Knoll's client can step up, Mr. Medell. All right, we're back on the record, CR 12133, State versus Ethan Logan Medell. Are you ready to proceed, Mr. Knoll?
We are, Judge.
All right, Mr. Medell, if you'll raise your right hand, I'm going to place you under oath. Mr. Medell, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you. All right, you can put your hand down. Mr. Medell, you appeared before this court on December 21st of 2017. And at that time, you pled guilty to the offense of burglary of a building. The court reviewed the evidence, found there was enough evidence to convict you of that offense, but the court deferred a finding of guilt based on a plea agreement and placed you on deferred community supervision for 5 years. It's been during your period of supervision that the state has filed a motion to adjudicate and revoke your community supervision. They filed that on December 18th of 2019. Have you had enough time to review that document with your attorney, Mr. Kurt Knoll?
Yes, sir.
All right, Mr. Knoll, is it your client's intention to waive the formal reading of that motion and to plead true to the sole count that's alleged in count 1?
That would be correct, Your Honor.
All right, and Mr. Knoll, do you believe Mr. Medell to be competent today?
I do, Your Honor.
All right, and you've explained to him his legal and constitutional rights?
I have. We met yesterday.
All right, thank you. Mr. Medell, then, as to count 1, as contained in the state's motion to adjudicate and revoke, how do you plead, true or not true?
True.
And Mr. Medell, are you pleading true to that count because that count is true and for no other reason?
Yes, sir.
And Mr. Medell, has anyone threatened you, forced you, or otherwise pressured you to make you feel like you had to plead true?
Sir.
Say that again.
No, sir.
Okay. All right. The court will accept Mr. Medell's true at this time. Mr. Knoll, any objection to the admission of State's Exhibit A, the defendant's waiver of rights and plea of truth?
No, Your Honor.
All right. State's Exhibit A is admitted into evidence, and the court takes judicial notice of Mr. Medell's judicial confession. Is there anything further from the state?
No, Your Honor. State would rest and close.
From the defense, Mr. Knoll?
No, Your Honor.
All right. Based on the evidence and the defendant's plea of true, the court will find that Mr. Medell has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court hereby convicts him of the offense of burglary of a building, assesses his punishment at 409 days in the Texas Department of Criminal Justice State Jail Division. The court awards Mr. Medell 409 days credit towards that sentence. Court orders him to pay the balance of his financial obligations, including restitution and court costs. Mr. Medell, when you get out of jail, you still owe a lot of money. You owe a lot of money to your victim, and you still owe money to the county. I'm going to order you to report to the Van Zandt County Courthouse or contact the courthouse and speak with the court's compliance officer so you can make arrangements to get on a payment plan so you can continue paying off the people that you owe. Do you understand?
Yes, sir.
And your failure to do so may result in the court issuing a warrant for your arrest, and we'll be right back where we started.
Yep. Yes, sir.
All right, Mr. Medell, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. And we'll need to have him fingerprinted before he is released, and I'll have Ms. Taberham send that paperwork out for fingerprinting. Thank you, Mr. Medell. You can have a seat.
Judge, I believe that's all I have, man. Go back to return to my Smith County Zoom.
If that's what you desire to do, yes, sir.
Well, I just
I was
soon
gonna say, I
say
think we
that
can keep him here for a while.
I need to finish one more over there, I think.
Yes, sir. We appreciate you. Thanks. Hey, Zoom helps you be in two places at once. It's kind of nice.
Yeah, except when they're actually going at the same time, yeah. Thank
Well,
you,
you
Judge.
can't have everything you want. Have a good day.
Yeah, apparently not. Thank you.
Mr. Parrish, you still finalizing your paperwork with Mr. Gray?
We have it ready, Your Honor. I don't know how I've got it in my hands. That's and ready to go and sign.
Okay. I'll train you up on this process.
Okay.
Yeah, sometimes it's this, sometimes it's that. All right, go ahead and have your client step up.
Hold on, Mr. Gray.
All right, this is CR 18312, State versus David Lee Gray. Mr. Gray, if you will, just raise your right hand, sir. I'm going to place you under oath. Mr. Gray, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, make sure you speak up. You put your hand down. Make sure you speak up loudly and clearly. I've got a court reporter here with me in the courtroom, and it's necessary that she takes down everything that we say, okay?
All right.
Okay. Mr. Gray, let's see. You are David Lee Gray, is that correct?
Yes, sir.
And Mr. Gray, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
Say that again, I can't.
Yes, sir.
Okay, what have you been diagnosed with? And if you need to, you can, and Mr. Parrish, I'll tell you what, if you'll grab that podium and just move on up closer to the camera, that'll be closer to the microphone, and I think that'll assist you, both of us. All right, what have you been diagnosed with, Mr. Gray?
I really can't remember.
Okay, are you on any type of medications right now or seeing any kind of psychologist or doctors for it?
No, sir.
Okay, and you're not on any kind of medication today?
I'll take some, but I don't know the name of it.
Your Honor, he
Okay.
takes medicine for an asthma condition. And, he's brought that medicine with him, so the jail staff can have it. But,
All right.
in terms of my client's cognitive abilities, he's definitely mentally competent. He understands the proceedings. He's been able to help prepare me for this proceeding and defend against the allegations in this motion to revoke. And he's been able to adequately consult with me with respect to a resolution on this case.
All right, thank you, Mr. Parrish. All right, Mr. Gray, you're represented by your attorney, Mr. Jason Parrish. Are you pleased with his representation of you? Do you feel like he's done a good job and answered all of your questions?
Yes, sir.
All right, you don't have any problems with him whatsoever, is that right?
No, sir.
Okay, and Mr. Parrish, you've already indicated to me that you believe your client to be competent today. Can you just go ahead and tell me,
Yes, Your Honor.
can you go ahead and tell me what the terms of the plea agreement are and leave out nothing, the level of degree of offense all the way down to court costs?
Yes, Your Honor. So Mr. Gray was placed on probation for possession of marijuana, a state jail felony offense. His original sentence was 2 years, probated for 2 years. The date of the original community supervision order was May the 14th of 2019. The state filed her amended motion to revoke community supervision with respect to Mr. Gray on December the 3rd of 2020. We are in receipt of that amended motion. I have reviewed the state's amended motion with my client and the contents of it. The state's amended motion contains approximately 6 paragraphs in it. The state has agreed to abandon count 1, count 4, and count 5 of the state's motion to revoke community supervision. My client is going to plead true to counts 2, counts 3, and count 6 of the application to revoke community supervision. And the agreement would be that the defendant would receive 7 months in a state jail facility, punished pursuant to Article 1244A. So his place of confinement would be here in the Van Zant County Jail.
All right, so the state's abandoning count 1, count 4, and count 5?
That's correct, Your Honor. All the allegations arising out of criminal conduct in Longview, Texas, we're abandoning and proceeding only on our technicals as observed here in Van Zant County.
All right, and Parrish, does your client waive the formal reading of the state's amended motion to revoke community supervision?
Yes.
Okay. All right, so Mr. Gray, the court's going to ask you at this time, how do you plead to counts 2, 3, and 6? Are those counts true or not true?
True.
Okay, Mr. Gray, and are you telling the court that those counts are true because in fact they are true and for no other reason?
Yes, sir.
And has anyone threatened you or forced you or pressured you to plead true to counts 2, 3, or 6?
No, sir.
All right, the court will accept the defendant's plea of true to counts 2, 3, and 6. Mr. Parrish, any objection to State's Exhibit A, the defendant's waiver of rights and plea of true?
No, Your Honor.
All right, State's Exhibit A is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor, just a couple of additional terms. It appears that Mr. Gray still owes $413 in fines from the original cause, and the state is going to be crediting him 10 days towards his incarceration towards the plea today.
All right, thank you.
That's correct, Your Honor. That's reflected in the judgment.
All right, then based on the evidence presented to the court will find that David Lee Gray has violated the terms and conditions of his community supervision. The court will revoke Mr. Gray's community supervision. Court hereby adjudicates his guilt. And what was that charge, Mr. Parrish?
Your Honor, it was possession of marijuana.
Okay, 4 ounces to 5 pounds?
4 to 5 pounds. Yes.
Okay. So the court hereby convicts Mr. Gray of the state jail felony offense of possession of marijuana greater than 4 ounces but less than or equal to 5 pounds. The court assesses his sentence at 7 months confinement in the Van Zant County Jail under Section 1244A of the Texas Penal Code. Court orders him to pay the balance of his financial obligations. The court awards Mr. Gray 10 days credit for time that he has spent in jail on this cause. So Mr. Gray, when you get out of jail, you need to contact the courthouse here in Canton and speak with the court compliance officer so you can make arrangements to pay off that $413 that you still owe so that a warrant doesn't get issued for your arrest. Do you understand?
Yes, sir.
Okay. All right, Mr. Gray, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you taken into custody at this time, and we'll have you fingerprinted with the bailiff.
Thank you very much, Your Honor.
Thank you, Mr. Parrish. If you'll just give that paperwork to the bailiff, then she'll take it from there.
I sure will. Thank you.
Thank you for your assistance today. All right, we still have Miss Dean to schedule, and I think that wraps us up this afternoon. State, you see any cases I'm missing?
All I have, Judge.
And Your Honor,
Yes, ma'am.
I did go ahead and send Miss Dean back to booking. Do we need to bring her back up here?
No, that's fine. If we'll just get a reset notice and let's set her for docket call on March 25th. She doesn't need to sign it. If you'll just fill it out for her with that cause number in that date and get her that yellow copy, I think that'll be sufficient for her. And we'll notify Ms. Thompson.
Yes, sir. Thank you.
And I've got an order finding her bail insufficient. And so I'm going to fill that out, and you can tell the bookend that I'll have that out there shortly.
Thank you, sir. And could you happen to have her CR number handy?
I do. Yes, ma'am. It's CR 20-288.
Thank you, Your Honor.
You're very welcome. Thanks for your help today.
Good time.
And I'd be remiss not to tell you happy birthday on YouTube. I'm not going to tell her.
Birthday, Aaron.
I know. How about that? She'd look at her. She didn't want to
Happy
look up.
birthday, Deputy.
Thank you, Tyler.
All right. Miss Dean's bond on the state jail felony offense. It was previously $1,500. I'm going to set her new bail at $25,000. Cash or surety.
Your Honor, is there anything else we can do for you out here at the jail?
No, ma'am, that's all. Thank you for your help.
Thank you, sir.
I'll see you soon.
Your Honor, may the state be excused.
State may be excused. Thank you.